It's very clear that the decision to find compliance with Armenian Constitution was reached before the writing of the opinion by the Constitutional Court. It was a political decision. That this is a political move by the court. The court is in compliance with the wishes of the President of the Republic, Sarkisian. So they had to come up with an argument because the overwhelming majority of Armenians in the diaspora and in Armenia itself are opposed to the protocols because of the dangers that the protocols contain regarding Armenian national interests. Now, the overwhelming majority of Armenians are not opposed to good neighborly relations with the neighboring countries, including Turkey. That's not the issue. The issue is, if we want to establish diplomatic relations, let's do it just like any other normal country does. United States and Turkey established diplomatic relations in early 1950s, 51, 52. It was a two-sentence letter just stating that United States of America and the Republic of Turkey hereby agree to establish diplomatic relations. That's all. Now we have two protocols for what nobody knows, and then these protocols contain seeds of political danger as far as Armenian national interests are concerned. So what the court did was to justify its decision to find the protocols constitutional by pointing these legal points. In the decision, there are 5 points, but basically we're talking about 4 legal points. First, according to the decision, these protocols are not multilateral agreements. These protocols are bilateral agreements between Turkey and Armenia. So no third country is involved. Now, this interpretation or this legal point shuts the door before any other third country to benefit politically or militarily or economically from these protocols. In fact, the issue is Nagorno-Karabakh and Azerbaijan. As far as Nagorno-Karabakh is concerned, the protocols have got no linkage to Nagorno-Karabakh issue. It has got no linkage. They've got no linkage with to the Republic of Azerbaijan. Turkey has been attempting to make this linkage, and if this kind of interpretation is accepted, that third countries have a right in this, under these protocols, then Turkey would be justified. But the Constitutional Court of Armenia now is saying that it is a bilateral agreement. There are no third parties. The second legal point is that these protocols have 2 basic objectives. These 2 fundamental objectives create mutual obligations and rights for Turkey and Armenia. And these 2 objectives or duties or obligations under these protocols are the following. First, establish diplomatic relations, and second, open the borders between Armenia and Turkey. That's the second point. The third point is that these protocols do not address 2 disputes between Armenia and Turkey. They do not solve any kind of disputes between the 2 countries. They do not create new rights, or they do not preclude new duties or obligations. It does nothing of that sort. They use the word sangutyun. The remaining provisions are just desires, wishes. They do not create any legal obligation. In order to create legal obligations in the future on these issues, on these sangutyuns or desires that these 2 countries want to achieve. They have to come to terms in writing and bilateral agreements, and those agreements have to be in accord of the Vienna Convention on Treaties of 1969 first, and they should also be in compliance with the provisions of the Armenian Constitution and the Armenian law on international treaties. So what it's saying is that the other provisions or expressions in the protocols are just desires, expectations for the future. They do not create any legal obligation. And the fourth legal point is the following. These two protocols do not establish, do not validify any kind of international agreement that exists in the past, such as, without mentioning it, such as the Treaty of Kars of 1921, the Treaty of Alexandropol of 1920, December 1920, and the Treaty of Moscow of March 1921. So these treaties, all the agreements, in order to be acceptable, they have to pass muster on 2 points. First, they have to be valid international treaties, and we know Alexandropol, Moscow, and Kars treaties are not valid. They are null and void agreements. They are not acceptable. Whereas the Sèvres Treaty and the 1923 Lausanne Treaty are acceptable. They are valid treaties, although Sèvres is not ratified. Now, that's one. The second point, in order to pass muster, is the following, that these treaties, even if they are considered valid under international law, they have to comply with Article 6 of the Constitution of the Republic of Armenia. And Article 6 provides the means and the procedures for the adoption of an international agreement. Because these treaties are not adopted by Armenia under the Article 6 of the Armenian Constitution, then they cannot be acceptable. So these are the four legal points. This is the bootstrap argument the court is making in order to justify its decision. It would have been easier for the court, by setting forth these legal points, to find that these points are not contained in the protocols. Therefore, the protocols are not constitutional and in compliance with the Armenian Constitution. These protocols cannot in no way, in no shape or no manner, they cannot contradict the principles set forth in the preamble of the Constitution of Armenia, and specifically, they cannot go against the provision that is set forth in the 11th point of the Declaration of Independence of the Republic of Armenia. Now, in the preamble of the Constitution, it says that this Constitution is based on the principles stated in the Declaration of Independence. And in the Declaration of Independence, there are 5 principles stated. The self-determination of Nagorno-Karabakh, historic rights of Armenians, and recognition, international recognition of the Armenian Genocide. They are all there. So the court effectively is saying anything that goes against the national self-determination of Karabakh is unacceptable, and these protocols cannot go against that, or against the genocide recognition, or our historic rights. And the 11th point of the Declaration of Independence not only talks about the recognition of the Armenian Genocide, it also mentions the commissions of the genocide in Western Armenia, which is currently occupied by Turkey and by the Ottoman Empire.